Last year in Japan after an earthquake and a tsunami is now the focus of a big lawsuit in an American court. Within days of the disaster, U.S. relief efforts were in full swing. American sailors and servicemen risking their lives to help those who really needed it. Now 8 sailors from the USS Ronald Reagan are suing the Japanese utility that owns the nuclear power plant, claiming it lied about the dangers from radiation leaking out of the crippled facility. Each sailor seeking tens of millions of dollars in damages and the creation of a $100 million fund to pay for medical treatment. Do they really have a case? Greg Gianforcaro joins us, a defense attorney. Doug Burns, also a defense attorney, former prosecutor. Doug, negligence is one thing.
Yes.
You know, whether they properly maintain the facility in a safe way. But lying is something different. Is that the sort of the second part of this thing?
Yeah, it's interesting, Greg, because they say they owe 2 duties. Not the normal one is to have a reasonably safe environment, and then they say there's also a duty not to misrepresent the level of danger involved. But I think, you know, jumping ahead a little, I think there are a couple of hurdles. One is sort of procedural, and that is, what's the jurisdiction over the person, so to speak, over the defendant in a California federal court? So I think they're going to litigate that. I'm not so sure they'll be successful in blocking the case from going forward. But the fact of the matter is, are there minimum contacts? The other point, of course, is the intervening act of God, tsunami, and other acts of God. And, of course, the defense is going to rely on that very, very heavily, in my opinion.
Yeah. You know, Greg, it seems like the damages may be a little bit way down the road, speculative for now, because some of these guys really aren't feeling any of the effects that, you know, one might otherwise expect in radiation cases.
Well, that's right, Greg. I mean, after what you get past what Doug was talking about, you've got the issue of damages. I mean, the fact is that right now they're healthy, and assuming that they may get cancer or a shortened life expectancy, I mean, to me, that's too speculative. Right. And I mean, for instance, my father was in the Army and back in the 50s was involved in the atomic bomb tests. He's in his late 70s and still healthy. Could he have argued back in the 50s that exposure to the atomic bomb might have shortened his life or might have given him cancer? I mean, I would almost say, look, if and when hypothetically they were to get cancer, if you could then connect it at that point, then come see me with regard to the damages, because I think that's the biggest hurdle that they have to get over.
Right.
I'm sorry, I got somebody talking to me in my ear, and I have no idea who it is. Doug, let me go to you. Proximate cause is something that plaintiffs have to prove. They have to prove a connection between an injury and negligence.
Absolutely. And of course, you're raising the distinction between the old, you know, but-for causation, which is, you know, but-for being there, this wouldn't have happened, but you have to show that it was the proximate last link that caused it. But to pile on even further on the plaintiff's saga here, you had 5,500 people on the Reagan, Greg, which I found to be somewhat staggering when I read that. Admittedly, apparently, the distinction is that these 8 were up more toward the surface. But again, I think they have a very tough case.
Yeah. Greg, in the end, what's going to happen to this thing?
I think it may get thrown out, frankly. I think Doug is absolutely right. They have an extremely tough case.
Yeah, well, and we wish them all well.
Of course.
Greg Gianforcaro and Doug Burns, thank you both.
My pleasure.
Thanks, Greg.
We'll be right back.